Hi, I'm Amy Privette, the attorney for Privette Legacy Planning, and I've been sharing with you a series of videos that I call the 5 P's of Revocable Living Trusts. And this is the third video in that series. If you've not yet watched the first 2 videos, let me encourage you to go check those out. You can find them on the firm's Facebook page. They are also shared on the What to Expect page of our website, which is www.leavealegacy.nc.com. So the third P for Revocable Living Trusts is prevention. And what we're talking about here is preventing children from accidentally being disinherited. To help you understand what I'm talking about, let me sort of paint a picture for you. This often comes up in blended family situations. So suppose we have 2 people who get married and they have their children, and then sadly one of those people passes away. So we have the deceased spouse and then we have the surviving spouse. Most of us in our wills probably say something along the line of, if something happens to me and I die, everything that I have goes to my spouse if they're still living. So in this world that I've created, the deceased spouse, everything that they owned and everything that they had has now been inherited and passed on to the surviving spouse. Well, at some point, that surviving spouse gets remarried and we now have the new spouse. In North Carolina law, you are not allowed to disinherit someone that you are married to. It's called the elective share statute. I'm not going to go into all the details of that law, but the effect of it is this new spouse is automatically entitled to inherit from the person that they are married to. And the problem that that creates is that the assets that this new spouse inherits from the surviving spouse will include the assets that the surviving spouse inherited from the first spouse. So it starts here, it flows to the survivor, and then when that survivor passes away, it flows to the new spouse. Well, who gets left out in that conveyor belt of inheritance is the kids. The kids from that first marriage have never seen a penny of what the first deceased spouse passed on to the survivor, their mother, their father. Well, who do you think are the heirs of the new spouse's estate plan? If anybody, it's probably his or her kids if they have kids, or their family members. It's highly unlikely that your kids are going to be the heirs under the new spouse's documents. And that means assets that should have eventually ended up with these children have now passed to someone else, and the kids are now accidentally disinherited. This is a scenario that we have seen multiple times with clients here at this law firm, unfortunately once it's too late to do anything about it. And we have seen assets such as the family business. We've even seen a ranch land down in Texas that should have gone to the children that ended up with the children of the new husband or the new wife. This is an area where trusts can help tremendously because we can design the trust in such a way to prevent those assets from being passed along and not flowing to the children. So if you would like to learn more about this prevention area of trust planning, please reach out to us. We'd be happy to talk with you about that. There are 2 more videos in this series, the last 2 P's for Revocable Living Trusts. Do make sure you check those out as well.